Good morning, everyone, and welcome to this first session of the day. So this session is hosted by INRIA, which is a National Institute for Research in Computer Science in France. And I am Daniel Lemétayer. I'm a research director at INRIA. And I have the great pleasure of chairing this session with Marit Hansen on my left. As you probably know, Marit is Privacy Commissioner of Schleswig-Holstein in Germany. So the focus of this panel is a risk-based approach to privacy. In some sense, we could say that it's more or less a continuation, I would say a natural continuation of the panels that we had last year on anonymization. One of the conclusions then was that it's more and more difficult today to draw a clear line between, on one side, anonymous data and on the other side, personal data, or between sensitive data and non-sensitive data. And so what really matters at the end of the day should be more a question of level of risk, of privacy risks for individuals and for society. So I know that Claude Castelluccia is going to talk more about anonymization, so I'm not going to elaborate on these, but if we wanted another motivation for the topic of this panel this morning, we can just have a look at the General Data Protection Regulation. I found no less than something like 70 or 80 occurrences of the word risk in the last version of the document. So, of course, the notion of risk is not new in this area, and we could even argue maybe that from the very beginning, data protection laws were there to protect or to reduce, to address technological risks. But still, it has gained a lot of prominence in the GDPR. So does it mean that we are moving towards a risk-based regulation of privacy? And if so, what are the limitations? What are the benefits of this approach? Among the benefits which are often put forward, we have the idea that assessing risks make it easier to calibrate privacy protection measures or to prioritize actions. And I think that Bojana Bellamy will probably tell us more about that. But how are we going to assess privacy risks? Are we going to agree on privacy harms and their severity? Are we going to address the adverse impact or negative impact on society? And another question which is of prime importance is whether the risk-based approach to privacy is compatible with the vision of privacy and data protection as fundamental rights. Something like one and a half year ago, the Working Party in 29 expressed its concerns that the risk-based approach to privacy should not be seen as an alternative to personal data principles and rights, and should in no way reduce or alter these rights. So, as you can see, we have many topics to be debated in this panel, and we are privileged to have prominent experts of various backgrounds around the table, and I know they have many things to say about this. So, for the sake of time, I'm going to stop here and introduce our first panelist, Bojana Bellamy. Bojana is president of the Hunton & Williams International Center for Information Policy, ICPL, right? Which is a political think tank based in Washington, D.C. and in London. And they have worked a lot during the last few years on the risk-based approach to privacy. So, Bojana, the floor is yours.
Thank you, Daniel. Yes, we are a privacy and security think tank rather than political think tank. But you know, privacy just becomes politics these days, so much more. So I'm delighted to be here, really. Daniel, thank you very much for organizing this panel. And panelists, I know some of you really look forward to a robust discussion. And it's really good time to be here in Brussels. We are so preoccupied with a number of privacy happenings and of course, the GDPR is looming, and I think this discussion is really important because we do have now a new law that we are going to have to implement, and as Daniel has said, we have to also consider and understand how we're going to apply the rules that are based on risk in the new regulation. So very pleased to be here, and of course very special thanks to Facebook who's given us this chocolate, because when the going gets tough, as at the moment we do need some chocolate, so I thought that was a very, very, very good. Maybe a health risk. Yes, a health risk, exactly, health risk, but it was fantastic to have a bit of chocolate to calm us all down. So let's, how do I move the slides? There we are, always the first question. So my job here is to perhaps set the scene, but I also want to tell you a little bit about the work that the Center for Information Policy Leadership that I lead, and we work with all the global companies and data privacy authorities, experts, have done in the space of risk management. And so let me put, first of all, a case for why I think risk management in data privacy and data protection is really important. You know, companies always consider risks. I was leading global privacy for 12 years in a major outsourcing and service provider company, and you know, we all did risk management, but companies always think about risks to themselves. What enterprise risk management systems are based to understand what is the risk to me if I do not comply with privacy laws. And that's how generally companies approach risk. But what we are trying to say here is that we have to turn the dial. We have to look at the risks to individuals, because in fact, that's what privacy is all about. It is about people. It's not about some data. It's actually people that sit behind data. So again, what are the risks to individuals? What are the harms? What is the negative impact that can come across because of any processing or technology? So, second point to make is that I believe really strongly that we are at a crossroad point. And what I mean by that is that the technology is really challenging how we think about privacy, how we are applying the rules, what are the best compliance mechanisms. In the world of big data, Internet of Things, artificial intelligence, connected world, we need some additional tools, some additional mechanisms to help us apply these fundamental rights of privacy to help us achieve best compliance. And that's why I talk about these innovative models of co-regulation and compliance as well. The third real point to make here is that in the world where we regulate every single piece of data, and data is air that we breathe, we have to prioritize. We privacy practitioners, but really we privacy regulators as well, have to prioritize. What are the areas, what are those uses of data that are going to create harms to individuals? And that's the one that we are going to be thinking about. Again, if I have your email in the context of business relationship and I just send you an email to invite you to come to this conference or to speak to you or have a panel, like the use of that data is probably not going to create any harm. But there may be other ones. Facial recognition, as I walk into a political meeting in a country where democracy is not a given, is going to matter, right? And so that's really what we are talking about here. And specifically, from a practitioner's point, we in the companies and organizations, we need to be able to explain privacy to non-experts, to people who haven't been doing privacy for 20 years and odd, for people who haven't got legal degrees, to privacy engineers, because these are going to be people who are going to be creating these new technologies. And so that's why I think understanding the risks and harms is really important. Now, to the point that Daniel has made, I really want to make it clear that the center's work, and my really strong belief is that risk-based approach is not there to replace the laws. It is not there to take away our rights. It is not there to be instead of data protection law, nor is it there to replace enforcement and supervision. But what it does, it actually, as I will show, calibrates compliance, calibrates that enforcement based on, of course, context of processing, on severity and likelihood of risk. And I know Henry will be talking to us a little bit about risks in some other areas of law. And you know, another thing to mention is that Daniel has said risk is becoming an increasing legal requirement and expectation of organizational accountability as well. Not only Europe, but privacy impact assessment has been a requirement in many laws, in many countries, and therefore, you know, I do believe that, you know, we as practitioners, again, have to think about this more. Now, the center has kicked off the project, as I have said, where we are trying to really look at the use of risk-based approach, but also very importantly, we are trying to understand what are these harms to individuals that we are really trying to guard people against. Are they tangible? Are they non-tangible, material, non-material? Are there some societal harms? And I think that's where we need to focus our work. At the moment, my belief is, and even the work the center has done with the help of many others, we still cannot find consensus on the taxonomy, identification of harms. Let alone understanding how severe, how likely they are. And we published 2 papers last year, which you were able to see as well. And we kind of put there a matrix of potential harms and how you can kind of start calculating. But of course, it's a very crude, very, very crude attempt to do this, and we do need more work. Particularly now, as in the regulation, we are going to have to practice risk management much more every day as we do this. So just to recap, I see huge benefits of risk-based approach to privacy because it actually delivers effectiveness. This is not a piece of law that is there for academics to debate. This is about protecting people, ensuring compliance on the ground, being effective for society, governments, for regulators, for us in the organizations as well that are investing in privacy compliance. So let me just very briefly outline for those of you who haven't read the 78 instances Daniel said where the regulation talks about risk. Let me just say how the new European Data Protection Regulation looks at risk. So first of all, there's going to be more flexibility for controllers and processors as well to build, implement, and demonstrate program and compliance that is based on risk. And the risk, of course, is defined in a number of recitals, and I've got a whole slide, we're welcome to look at it, quite a number of tangible and non-tangible risks, but also based on likelihood of severity, as well as nature, scope, and purpose of processing. So that's the point, that's a general point. So we've got this sort of horizontal application of risk. Then there are some specific legal obligations that are based on risk, such as privacy by design, such as data security. And data security perhaps is one area where risk has been so very well practiced, so we do have to learn from some of the information security practitioners as to how they look at risk and apply as well. And then there are some specific obligations that only apply where there is a high risk to individuals, such as the duty to notify regulators, data privacy authorities, and individuals in case of security breach. Now, there is no need to notify for every single breach, but only those that create high risks of harms to individuals based on likelihood and severity. And the same applies for privacy impact assessments. Privacy impact assessments are not obligatory for every processing, but just for those high-risk ones. So we have to be able to work through this new regulation. There is going to be future guidance by data protection authorities that are at national level going to be defining some of the risky processing. You can imagine as a practitioner, I am a little bit concerned as to how each DPA will come up with a list of what they considered risky processing, and incredibly important, as Marit will probably debate and discuss, to have this consistent view across the EU. We are talking about digital single market strategy for Europe. We need to have technology and risk defined in a similar way. So excuse me, yes. Finally, I'm finishing now. I just wanted to perhaps spend just a moment explaining how RISC calibrates privacy program. On the slide behind me, you're going to see what are the elements of organizational accountability, what the elements of privacy program look like. This is recognized in the regulation, not explicitly, but implicitly. Risk assessment is in there. And what I have been saying to organizations is that at programmatic level, you have to develop programs that actually are based on risk. So if you are doing lots of big data processing, if you are deploying technologies with sensitive data, that's where you have to think more perhaps than if you are, as I say, doing just a trivial processing. And of course, at a micro level, when companies are conducting, when they're thinking about legitimate interest processing, when they are conducting privacy by design reviews, privacy impact assessments, dealing with security, dealing with breach, these are all going to be cases where we are going to have to deploy risk management. So, with that, I look forward to listening to the rest of the panel, and just very, very last point to make. Because of this, we really need to work together, and I'm really interested in your input offline, and of course, not only at this panel, as to how do we classify, how do we assess, and how do we create consensus around really risks and harms to individuals.
Thank you very much, Bojana. So I'm the moderator here, which means that I'm not supposed to say anything but only moderate, which is of course not what my understanding from as a data protection commissioner.
You must say something.
Oh, I have to say something, and if Caspar is not here, we have to have other people who raise the voice. Now, after each part, you're allowed to ask 1 or 2 questions, and then we hope to have a few more minutes at the end to put everything together. So if anybody raises the hand now to ask a question, otherwise I'll ask. So you're happy with the regulation because it's already the risk-based approach encoded in the regulation?
Yes, I am very happy to see this in the regulation. This is certainly a sign of a more modern approach to policy and lawmaking. There's a huge interest around the world as well on this model. There are, from Brazil to Singapore, Canadian commissioners and regulators, quite a lot in Asia, are going to be basing some of their development, future development of privacy law on what we are seeing in the regulation. So very happy, but we've got work to do to understand how we're going to apply this in practice.
Okay, I've several more questions, but I think there will be more in the other talks as well. So, for example, how to calculate really the risks, and that it's not the same thinking of, as you told, that the company thinks about risk already, but not for individuals, but for themselves. So, how to turn that? I think that this will be also tackled by others. So let's keep it for the discussion. And now I propose that we go ahead, and Danielle will introduce the next speaker.
Thanks, Marit. It was an excellent transition towards the next talk. So let me introduce our second speaker, Claude Castelluccia. Claude is a research director at INRIA, and he has more than 20 years of experience in security and privacy protection. He leads a research group at INRIA, which is called Privatix, which is entirely dedicated to privacy. And his main interests today are anonymization and authentication. So, Claude, the floor is yours.
Okay, thank you. Can you hear me? Okay, thank you, Daniel. So Daniel asked me actually to give some technical issue on the risk aspect of privacy, and I think there is one area where the risk-based approach cannot be discussed. It's actually data anonymization, because by nature, data anonymization is risk-based, right? There is the binary approach to anonymized data does not make sense. There is no such thing as fully anonymized data, except if you publish random data instead of the actual data, which doesn't make a lot of sense. But we have different levels of anonymizations, going from pseudo-anonymization to k-anonymity, or differential privacy that provides strong a guarantee. The important thing as well is that the level of guarantee change over time, because as you release more and more data, the risk, of course, will increase, and new attacks will actually make the risk, the risk even more higher. So data anonymization is clearly a trade-off between privacy and utility. So this is actually a graph that shows this trade-off, and I borrowed actually this slide from Daniel Bard-Jones.
Can we do anything about this?
Oh, sorry, I should move, sorry. I forgot to move.
The most
okay, so you missed. Sit down. Okay, sorry. Yeah, but I cannot see the... Okay, so I'm sorry about that. So the graph, actually, I think it's a very nice illustration of the privacy risk versus utility trade-off. You see the blue dot actually is the optimal situation where you try to get optimal utility and optimal protection, which is actually not possible for mathematical constraints. So basically it's a trade-off that you have to do between privacy and utility, data precision. So you have to stay on the curve, and basically you have to make a decision according to the utility you want to have and maybe the risk you're willing to take if you want to take any risk in terms of privacy. I'm sorry. So data anonymization, it's clearly an optimization process that tries to find the best trade-off that minimize the risk and optimize utility. And so therefore you have to define a utility matrix, which basically will be how you're going to qualify the quality of the data, which is actually challenging in some area, like in big data, because most of the time people do not know what they want to do with the data. So the utility is very hard to define. And you have to perform a privacy risk analysis in order to evaluate the risk of re-identification, or what we also call identity inference, but also attribute inference, right? So re-identification often is not enough. You also want to make sure that by different attacks you cannot actually infer some hidden attributes. So this is typically how we perform a risk analysis when we anonymize a data set. Basically, we define a set of feared events or feared inferences. Like, for example, a feared event could be that the data leaks the religion of the people that are part of the data set. Then we have to define a set of adversary, okay, and we have to quantify how powerful those different adversaries are. And also, for each of those adversary and feared event, we have to try to quantify the impact for the people if this event appears, and also the likelihood that this actually event will appear. And using all these parameters, we can try somehow to quantify the privacy risk. Of course, this is actually very challenging, and there are like many technical issues, challenges that need to be addressed. For example, the first one is how do you actually define an adversary? How do you quantify the background knowledge that the adversary has? You know, because if you anonymize using some kind of background knowledge that the adversary can get from social networks or whatever source of information that can help him to re-identify the anonymized data set. You also need to quantify the computational power and the budget that the adversary has, and of all these various adversaries. So this is actually not trivial. You also have to quantify the harm to the people that are part of this data set, which is also, I think it was already alluded before, which is hard because it's often contextual, and the perceived risk actually might vary from one person to the other, and also might also vary from one culture to the other, right, in terms of privacy harm. So this is actually hard for computer scientists to evaluate, to quantify those metrics. You also have to, once again, evaluate the likelihood of this re-identification for the adversary. And so this is actually where most of the research is being done in computer science. The typical solution consists of looking at the data, try to identify the quasi-identifiers in the data set, and somehow evaluate the unicity of those quasi-identifiers, right? Because if a quasi-identifier is unique, it can be used to re-identify a user. So there have been like very nice paper recently that shows, for example, it was a paper that was published in Nature that shows that it's enough to get 4 geolocalization information of a user to actually uniquely identify this user in a data set of 10 million users. So you don't, even without the phone number, if you only know 4 locations of this person, you can re-identify it. We showed actually also last year that it's enough to know 5 or 6 mobile apps that a user has on his smartphone to also re-identify him uniquely. Same thing with the web history. The way people browse on the internet is unique. which means that this can be also used as an identifier. So it's not enough just to remove the known identifier, you also need to look at the quasi-identifier. So this is actually, I would say, the current approach. The new approach is actually algorithmic approaches that actually use techniques like machine learning or deep learning in order to re-identify. And this is actually a very exciting area. And the main idea is try to automate this re-identification process in order somehow to quantify the level of complexity. And there have been like very nice results as well that shows that techniques such as machine learning could be used to automatically re-identify social graphs or social networks. Another paper showed that you could also identify, for example, the author of a program, the code, from the way the code is written. And the amazing thing is that you can also do it if the code on the binary code, so after compilation. So I'm not going into the details, but it shows that actually those tools are very powerful. The last challenge is actually attribute inference. So far I mostly talked about the re-identification, but there is something that is very important, which is attribute inference. So even some anonymized data set could actually reveal personal information about people, because people are correlated, they have behavior that are correlated. And so basically you can learn a lot of things from a user by looking at the data of other users. So typically you can think of a medical data set that shows that smokers have a higher chance to get some lung or respiratory problems. So this is a naive example, but it means that this kind of result will impact all smokers, even the ones that were not part of the data set, right? So if you follow the re-identification problem, it actually would be safe to publish this type of result, but still it has some kind of impact on the privacy of smokers, because you can actually infer some sensitive information about these people. So we also need to consider this kind of what I call group inference in the risk analysis, and try to balance it with the benefit. For this example, for example, it might be, the benefit can be very large because it's medical data, so it can contribute to everybody, it can benefit to everybody, but it's not always the case. So we also need to perform, I think, together with the risk analysis, a benefit analysis, especially for this type of data. But of course, there are a lot of technical issues, like how do you identify all possible inferences? So this is actually quite trivial, the example I gave, but there are a lot of inferences that we don't even know how to actually get them. And how to evaluate the likelihood, again, that's also a challenging problem. The other question that sometimes I'm wondering is, where is the limit between privacy and ethics? So some people are actually arguing that this type of problem, where you're inferring personal information from inference, is more an ethical issue than a privacy issue. So maybe that's something that it would be nice to discuss. So the recommended measure for me will be, first of all, the risk analysis should be conducted and audited by a neutral, independent third party, as opposed to security analysis, because we're trying to protect humans here. We're not trying to protect the asset of a company. So it's the fact that it's done by a third party, I think it is essential. The risk analysis should be performed periodically, re-evaluated periodically. So the approach that, we should avoid the approach release and forget. So you publish, you anonymize and release it, and you're done. I think it's important to make sure that you need to reevaluate it, so you should not forget about the data that has been anonymized. And we should also support for the development and the standardization of rigorous privacy risk analysis and tool. And I think there is clearly here a need for more research. Clearly more research necessary. I'm done with the time. Or?
You have one more slide.
Okay, one more slide. So this is some nice references. So if you
he has done work on that.
If you want to look at more information, I urge you to read these nice papers. And I think that was the last one.
Okay, thank you very much, Claude. We are a little bit in a hectic here because of all the time constraints, but still, I think the messages are very important. There's a microphone in the middle, by the way, so if you want to queue there, you will get your question. Otherwise, again, I play the game and will ask my question. So you made clear that still there's no solution to calculate the risk for individuals for the harm? You said it's hard. It may even be impossible. We don't know. Or how to phrase it. And then also the next thing, if it's already done in the regulation, but here we have the third party idea of the risk calculation, which I think is the right one, so not the data controller itself, but somebody outside, then I think this is not really part of the regulation, and it's right now a very hard or even impossible and probably time-consuming and expensive task. So I think for a research proposal, fine, you will get much money, but for a solution, how to go ahead now? You want to answer that?
That was a question. I mean, yeah, it's a hard question. I mean, for me, we don't have the right tool today to perform a subjective risk analysis. So what is done today, it's mostly an objective risk analysis. So you have to do your homework, perform the risk analysis, and then whoever is deciding will decide on some kind of basis. But as a scientist, I think it's a bit frustrating, actually, for us computer scientists to rely on this type of risk analysis.
Okay, and I have another one. So you said also, what about if you publish the anonymized data and the anonymity is perhaps not perfect or definitely not perfect? So perhaps then the consequence would be not to publish the data, where you have the strong belief that after 10 years' time it's not anonymous anymore. So that the consequences could be regulated more. Right now it's only the binary approach, like it's anonymous, you can do everything, it's lawful. And right now we hear it's not really that binary approach, it has to be something in the middle. And it's not only about the balancing with utility, but also about what are you allowed to do with the data. Right now it's not in the regulation.
Right, I mean, I'm not a lawyer, right? But I think, anonymization is not the only solution. So when you have any risk, I think there should be some kind of legal contract to make sure that if something happens, there is some accountability in the process.
Yes, I think this can be one question for the very end, or do you want to comment right now? Okay. No further question, then Danielle will introduce the next speaker.
Thanks, Marit. So let me now introduce our next speaker, Raphael Gellert. Raphael is a PhD candidate in the LSTS group here at VUB. And his research focuses on the regulation of science and technologies. And recently, Raphael has published a very interesting paper in International Data Privacy Law. And the paper is entitled Data Protection, a Risk Regulation Between the Risk Management of Everything and the Precautionary Alternative. So I think it's at the core of this panel. So Raphael, the floor is yours.
Okay, thank you, Daniel, for the introduction. So my presentation is more a sort of a theoretical journey I want to take you with me. And as you see, so the title of my presentation is a bit provocative. And basically what I want to do with this title and this presentation is sort of to challenge, the way the opposition that is, the basis of the debate between the legal approach and the risk approach. And by the way, so I know we have time constraints, so I may have to fast forward on a few slides, but I'll do my best to be consistent. And so basically, the way things are presented is that the legal approach, so of course it's legal knowledge and it's a matter of compliance, so it's either we comply, either we don't comply. And in opposition to this, we see the risk approach, so it's not so much about law, it's about risk management, organizational knowledge, and so on, and it's more about the degrees of risk, so how much of a risk can we take. And so this is basically the standard opposition, and what I want to do in this presentation is kind of question this opposition and maybe come to the conclusion actually the two approaches are identical, they are not so different, but they're also different. So they are not different in the way that is presented here, but they are nonetheless different in other ways, and they're also similar in ways that maybe we have not thought about. So the starting point to do this is to look at data protection law, not so much about the sort of legal translation of privacy, so data privacy, informational self-determination, or things like this. It's more to look at data protection law as a sort of a law, a legal framework that regulates the risks from information and communication technologies to fundamental rights. And, well, the reason why I do this is because once you start thinking about data protection in terms of regulating the risk, you enter the territory of regulation and regulation theory. And the interesting thing in regulation theory is that basically it always gives these three constitutive elements of what a regulation is. And so we have standard setting, which is basically determining what is the quality of the activity for the activity to be allowed. So, what's the quality, how good, how bad, and so on. And then we have monitoring, so making sure that regulatees respect these standards. And then we have behavior modification, which is about classically enforcing or sanctioning. And so basically what I will do now is mainly focus on the standard setting provision. And so what I do is basically I try to think, so what, if we think data protection is about regulating, what is the standard setting in data protection law? And my intuition is that when we look at the core principles, so both in terms of the data quality principle, but also in terms of a legitimate basis, I think this can be very much seen as the standard setting part of data protection law, because the processing must be fair and lawful. We have to respect the purpose specification, have data accurate, have a legitimate basis, and so on. And basically, when we have done all this, we say, okay, the processing, is good enough. We can go on with the processing. We can process the data. So this, I think, mirrors very much the idea of standard setting in regulation. And so, going on from this, basically, so we can say that data protection is about standard setting. And what we also see when we look at risk management, we also hear a lot that it's also about standard setting. Because, as you may know, so risk management is based on two steps. First, you assess the risk, and you ask yourself, how big is the risk? And then you do the management, and the question is, do we take the risk? And basically, this is described as the standard safety activity, or in other words, how safe is safe enough for the organization to take the risk, and eventually the organization needs to take risk reduction measures, or risk, also sometimes called risk mitigation measures, and when we have reduced the risk enough, then it's safe enough to be taken. And so I think it's quite interesting, because we see that if we frame the issue this way, we see that both data protection is about setting standards and also risk management. And so going a bit further there, further on this kind of similarity, and okay, maybe here I will go a bit fast, but we see that basically what is exactly standard setting? When you look deeper into it, actually you can see that it amounts to a proportionality test. Because when you do risk management, basically what do? You do a proportionality test. You see what are the costs, what are the benefits, and if the benefits outweigh the costs, then it's safe enough, and you can take the risk. So it's pretty much this. And actually, if you look also at the data protection core principle, the principle of proportionality, it's been written a lot about it, that there's a very strong link to the principle of proportionality. And so what I've tried to do in my research is sort of to map, where this principle of proportionality is in the core data protection provisions. And so what I see is that it's mainly based on the provision, so that the processing should not be excessive in relation to the purposes. So for me, this is the basic balancing proportionality activity. And then if you look actually at the other safeguards, so the other data protection core principles, we see that actually they look very much like the safeguards that, for instance, we can see in Article 8.2 of the European Convention of Human Rights. So, we have safeguards in terms of transparency. This is the processing should be lawful and fair. We have safeguards in terms of scope, in terms of quality, in terms of basis. And so, actually, if you look at this, these safeguards are also sorts of risk reduction measures, risk mitigation measures, because we have to process as little as possible, only for one purpose, or at least not for further incompatible purposes, and so on. So we have really this idea that we have proportionality tests plus risk reduction measures. And yeah, as I said, this is exactly also what is taking place actually with risk management practices. And here I just have sort of example of risk mitigation measures from the, I think this is the ICO PIA guidebook from 2014. And we see that basically these risk mitigation measures are, exactly mirror the core data principles. Just to finish now, so now I've showed that if you look at it from this perspective, it's very similar. But as I said, I don't think it's identical. And I think one way in which it's not identical is that in risk management, so we have two steps. So we have first risk assessment, which is about assessing the risk, how big it is, and then risk management, which is dealing with the risk. And actually, if you look at this perspective from data protection, well, data protection is only about risk management. So there's no risk assessment step. There's no, issues about the harm. This is underdefined. And now I just have 2 more slides to conclude. Basically, so can we also articulate this legal and this risk approach? And here, I think that sometimes the fact that there is a risk assessment step in risk management can be useful. I was thinking, for instance, sometimes it's been written that there's a conflict between the principle of data minimization and the principle of data quality. Because on the one hand, data minimization requires to process as little data as possible, and then data quality requires to have the data accurate, up to date, and so on. And so this, of course, requires some amount of processing, which directly conflicts with the idea of minimizing as much as possible the data. And the same idea is also with discrimination. Sometimes you need a bit of data to be sure you treat a person fairly, and again. So I was thinking maybe, there's here the issue of risk assessment in determining the risks can be useful in, finding what's the right balance between these sometimes conflicting principles. So I have other thing. And then a last slide here is about what are also, when it does not work, what are the potential pitfalls. And I think that, well, risk management, as I said, is about organizational knowledge, whereas law is also, at least European and Western systems are, deeply embedded into constitutional law, rule of law, and democracy. And I think these are some important, if you will, elements that should be taken into account when we manage the risk. And I think, for instance, we have the Schrems case where basically Safe Harbor was taken down because it was putting the essence of the right to data protection at risk. So what does this mean? I think that this means that when we do, for instance, a risk assessment, and we see that there is a risk that the essence of the right is encroached upon, well, this means that we cannot go on with the processing, no matter if the likelihood is 0.01%. I think that in this case the risk is so big and so essential to our constitutional values that we cannot go on with it. I think another element is the necessity test. So it means to look for alternatives. So basically, which is very much part of the jurisprudence of the European Court of Human Rights and also in the Charter of Fundamental Rights. So this means that whenever you have the possibility not to process data, you should not process data. And I think this is very much part of our constitutional tradition. And also the principle of purpose specification principle, which is enshrined in Article 8 of the Charter for Fundamental Rights. So this is really a safeguard or risk reduction measure that is of paramount importance. And I also had a few more things on risk, but maybe I'll leave it
Perhaps for the discussion. Thank you very much.
Okay, thank you.
Again, if you have questions, please come to the middle or to the microphones. And yeah, you have one? Okay.
As part of the paper session, there's a very enlightening paper by a young scholar named Milda, and I'm probably saying her last name incorrectly, Macente. But it talks about risk regulation in other contexts, including the environmental context. And in that context, one thing that seems very different from what you all have described is that there's public participation in the definition of risk. Could you each talk about, if it's relevant to your work, how the public might be able to participate in the definition and assessment of risk as we have in, let's say, food safety and environmental health, et cetera?
Okay.
Okay, you want to answer that because I think Henry will also tackle related parts, so not so much the DP, data protection areas, but the rest. But if you have a quick answer, and then we take it from there.
Yeah, so just a quick answer. Well, if you look at the GDPR, there's also a provision for the data subjects' participation in data protection impact assessments. So that's one element. I think, of course, there are a lot of caveats in how participation takes place. So for which risk do we do this for all risk assessment, for which organization, for what type of risk? But I think, this is my personal view, but I think it's of paramount importance because, as Claude said, the definition of what a risk is, I think, it's always contextual. It always depends on the person involved. So I think this is, of course, it's very important. But I would also like to say that, it's also important not to idealize what is taking place in environmental law and in health law because public participation has been, one of the purportedly important elements in environmental law for the past 30 or 40 years, but there has been so many disappointments that, I think it's also important not to say, they are doing this perfectly and in privacy we are not doing it at all. So of course in privacy now it's a new issue, and I think we have much to learn in the way that they do it in environmental law and personally, I strongly support, of course, the issue of public participation.
So thank you for the question, and indeed the panel wants to answer. So you one sentence, and then Henry will go from there because I have more questions. But for the sake of time, I'm not sure whether we can go a few minutes into the break later on. Okay. So one sentence.
Yeah, I think it's a great question actually. And as a computer scientist, we like to be rational, right, and make a rational decision from the risk. And actually, it was shown that people are not rational. And the question I'm wondering sometimes is that, do we have to make rational decisions or not? So do we have to listen to people and sometimes make decisions that are not rational? Or should we just have some kind of computer scientist approach of making rational choice? I think this is related, and this is actually a very nice, important question to me.
Okay. So let me address this. So this was actually... This topic, Chris, I think it is, isn't it, has been debated a lot as part of our project where data protection authorities and some of the academics who were working with us said, well, risk management is all in the hands of organizations. How do we make sure that individuals are represented? What is the role of individual in this? And the same question gets asked as well as we talk about accountability and organizational responsibility, corporate digital responsibility. Again, what's the role of individual? Because we say organizations should take steps. They are the ones that have got onus to do the right thing. And so I would say, so that's true that individual can only be empowered if organization is accountable. And so the two are linked from that perspective. The second point is we do have a number of, as Raphael has said, tools in our toolbox in data protection laws that enables individuals. Transparency. As part of transparency, it's not about telling people in privacy notice 20-page long about some legal stuff that nobody reads. Transparency is about managing relationship with your people, with your individuals, and addressing their concerns, potentially addressing their concerns of harms and risks as well. So I think we're going to see evolving transparency where perhaps that is going to be taken into account. Legitimate interest processing, again, where you must take into account individual rights and assess whether your processing is overrides or not, or is overridden. Again, risk is part of that test. If you got that right, individual has right to object. The EPAs have got right to challenge you as well. So even though organizations are the one to actually take a first view of the things and say, here is how we've assessed the risks, this is what we think, this is all challengeable. Right of access may provide for some of this as well. So I think we do have the tools in the toolkit, we just have to understand how to use it. And the final point I would say is that there's been lots of discussion about this, again, at our project, and we thought that as organizations consider the risk and inform themselves about what your Joe blog considers risky and harm, they are going to be doing focus groups. They are going to be doing their own research. And you have heard that Stephen Dedman from Facebook keeps talking about this all the time. How much time their people are spending in understanding functionality of the website. If we just spend that time understanding privacy, concerns, harms, risks, transparency, what it is that people want, I think we could it would be great. So that's where we have to, I think, move. I don't know if this is a good answer, but it's a beginning of an answer.
So thanks for the answers and thanks for the question. It was actually an excellent transition towards the last talk. So let me now introduce our last speaker, Henry Rothstein, who is a senior lecturer at King's College in London, and is also deputy director of the King's Center for Risk Management. So I should say that Henry is not an expert in privacy, but he's one of the best experts in risk regulation. So he's going to bring to this panel his broader view on this topic and maybe tell us what can be learned from other fields about the risk-based approach. So Henry, the floor is yours.
Well, thank you very much. I do feel a bit of an intruder here since I'm not an expert in privacy and data protection at all, but I have been studying the emergence of risk-based regulation in other policy domains and countries, from workplace safety for many years now, and I think many of the kind of points raised so far today really echo the profound challenges posed by the central conceit of risk-based regulation, which is that rather than eliminate all harms, it's more socially optimal for regulation to control those harms deemed unacceptable according to ex-ante calculations of probability and consequence. Now, over the last decade or so, risk-based probability impact frameworks have emerged as a key tool of regulatory reform, particularly in Anglo-Saxon countries, where it's colonized decision-making across many policy domains. So while its origins can be traced back decades, actually if not centuries in some common law jurisdictions, it really established itself in the United States in the 1980s as a core principle for determining the stringency of regulatory protections for public health, safety, and the environment, in response to the US Supreme Court famously striking down a workplace standard for the carcinogen benzene as unjustifiably strict. And since then, the OECD and the World Trade Organization have advocated and mandated risk-based approaches as global instruments of better regulation and free trade. Now, in the UK, which I'll talk about just for a bit, the approach was first applied to workplace health and safety about 40 years ago, when it was established that workers should only be protected against harm so far as is reasonably practicable, with that legal standard judged according to an ex-ante calculation of probability and consequence. But since then, risk ideas have increasingly spread to other domains. So, for example, the Environment Ministry's euphemistic phrase, making space for water, captures a conceptual shift from flood defence to flood risk management, in which government has explicitly sought to define the limits of its flood management responsibilities. Likewise, at the sharp end of policy implementation, when violent criminals have committed offence on release from prison, probation officers have notably defended their actions in terms of managing risk rather than securing public safety. Now, since 2008, all regulators in the UK, all regulators, have had a legal obligation to make their regulations, regulatory interventions risk-based. So this has encompassed not just the kind of the regulation of simple public bads, such as workplace injuries and food safety, but also the provision of public goods, such as housing and healthcare. So, for example, higher education, universities, are now subject to a risk-based regulatory regime that's constructed new categories, such as academic risk. Now, I used to just think of myself as a rather dull academic, but now it appears that I'm officially a risk to be assessed and managed. If not, thanks to the kind of the socially optimizing logics of risk-based regulation actually eliminated. Now, my comparative research suggests that risk-based regulation will only be successful when a number of institutional preconditions are fulfilled. And in the short time I've got now, I just want to outline just a few. The first precondition, and I think this has been picked up by several of the panelists, is that there has to be clarity over what risks are being regulated. Now, while regulatory goals are clear in some policy domains, such as workplace safety, where risk is defined in terms of work-related injuries, sickness, and death, in other domains it's actually much less clear. So take, for example, healthcare quality. In the UK, for the last decade or so, healthcare quality has been subject to risk-based regulation by a succession of regulators who've really struggled to define what healthcare quality is. Is it the simple provision of excellent hospitals and doctors, perhaps qualified by efficient use of resources? Is it better captured by procedural compliance with best clinical practice? Is it better captured by patient outcomes or even patient satisfaction? Is it all of them or yet others? Now, in that context, it's perhaps no surprise that in the last 15 years, care quality standards have been redefined at least 5 times, with new definitions typically layered on top of old ones following crises and shifting political priorities to create an ever-expanding list of complex and often competing goals. And that instability has made it very difficult to operationalize effective risk-based approaches to regulating what's essentially been a moving target. The second precondition, and again this has been picked up, is that even if regulatory targets are clear, there has to be sufficient information about probability and consequence in order to risk assess the regulatory problems. In an age of big data, as we've heard, I think there's much optimism about the possibilities. So in the UK, flood risk management has been underpinned by the intensive development of flood risk maps that have proved quite effective in predicting where the next floods are going to be. But other domains have struggled. So take, for example, England's Higher Education Quality Assurance Agency, which has tried to use a risk-based approach to organising the inspection of all higher education institutions, universities such as my own. Now, research by my PhD student, Alex Griffiths, has shown that out of the thousands of indicators that could be used to predict likely non-compliance with the regulatory regime, no single indicator or combination of any number of indicators can be used as reliable predictors of non-compliance that could help direct effectively inspection resources. So as the Times Higher Education depicted the research, it was like a children's game of pinning the tail on the donkey. And without giving it away too much, we suspect similar problems may be dogging the targeting of healthcare quality too. Third precondition is that there has to be an agreed basis for optimizing trade-offs between competing regulatory goals, such as safety and cost, and I think this speaks a bit to the last question. After all, we mustn't forget that risk-based regulation is founded on a utilitarian logic of regulatory intervention, determining who gets protected, who doesn't, who gets targeted, who doesn't, all according to what is socially optimal. Now, such trade-offs are possible in some regulatory domains where the distribution of politics favours agreement, such as workplace health and safety, which is principally determined by the narrow sectoral interests of workers and employers in striking trade-offs between jobs, job security, profits and safety. But such bargains are much harder to strike in other domains, such as food safety, where the consequences of failure are distributed across a much wider set of interest groups and stakeholders, not least consumers, who've got no reason to compromise their goals. So it's perhaps no surprise that the basic goal of food safety regime is, well, safety. Now, even if ex-ante agreement can be reached on regulatory goals, that's not always matched by ex-post politics after harms have occurred. So take flood risk management in the UK, where lightly populated rural areas are often designated as water retention zones in times of high water in order to protect more densely populated urban communities downstream. But in one case, just a couple of years ago in the Somerset Levels in the southwest of the country, faced with a small but very vocal population and national TV cameras rolling, the British Prime Minister, David Cameron, expressly denied there were any trade-offs to be made between protecting towns and farmland and insisted that money would be no object in funding reconstruction. Now, these three preconditions pose very serious challenges in countries such as the UK, where risk has really become a central means for regulatory legitimation. But there are very good reasons to argue that risk ideas face even tougher challenges in the rights-based constitutions of continental Europe when they can come into conflict with very strongly entrenched ideas about the role and purpose of the state in preventing harms. So take France, for example, where the inherently discriminatory logics of risk-based interventions comes up against the French constitutional principle of equal rights embodied in the revolutionary constitution. So, for example, during the 2009 H1N1 flu pandemic, the French Minister of Health had to decide whether to provide vaccines for the 30% of the population necessary to provide herd immunity or to provide the vaccines to everyone. Well, in the event, and here she is herself getting the vaccine, she decided to provide it to everyone, having no legal grounds to decide which third should get preferential treatment. Just about to finish. So in a constitutional context where everyone gets equal protection, risk is conceived less as a discriminatory logic of intervention than as an object for regulatory action to express social solidarity. Or take Germany, where risk-based regulatory logics face different problems in a constitutional setting that emphasises the negative rights of individuals against the state. And here the problem, I think, is historical insofar as the 19th century liberal conceptions of the Prussian state regard the protection of people from dangers to life, freedom and property as one of the very few legitimate grounds for the state to interfere in individuals' lives. But dangers were broadly dealt with in binary terms. If there's no danger, then there were no grounds for state action. And with the evolution of the Rechtsstaat after the Second World War, this constitutional principle of Schutzpflicht, which defines a threshold of danger that has to be reached before the state can legally interfere with private rights, has become increasingly important. So while the courts recognise that some small residual risk can be tolerated, they've struggled to find a mechanism for reconciling binary ideas of danger, no danger, with ideas of acceptable risk. So that helps explain, I think, the intractable legal conflicts throughout the 70s and 80s over nuclear power between stakeholders seeking to protect their conflicting but constitutionally enshrined rights to economic activity and health protection. So in conclusion, the point I want to make is that even in national contexts where utilitarian logics of regulatory intervention are broadly accepted, risk-based regulation faces serious challenges of identifying clear regulatory goals, assessing risk, and securing ex-ante and ex-post agreements on what is acceptable risk. But in other national contexts, the relationship between risk and regulation can take on an entirely different meaning.
Thank you very much. So the Schutzpflicht, I'm coming from Germany, meanwhile is interpreted sometimes as something not so binary because then the state gets the task or has the task to support people, to empower them to protect themselves, which is meant not so much as an interference, but of course there are other examples where it's really intervention.
Well, I think it's shifted from a kind of sense of expressing negative rights to actually embody more positive rights, hasn't it?
Indeed. And another problem here may be the cultural differences. So you pointed out that there are historic cultural differences, and Bojana in the beginning pointed out we need same understanding for interpreting the data protection regulation. Now we have people here from the panel who want to comment, but I think the public participation here is very important, so the question is here. The floor is yours.
Thank you. Thank you for the interesting analogy as well with the flood risk management. If we look at flood risk management, we can define a couple of metrics of square kilometers that are flooded, number of families displaced. When it comes to data privacy, this seems to be a challenge. Is there some form of metric the panel could propose, or some form of how do we compare what, well, we can easily assess what the risk is, so what the probability is of a risk occurring, but what the impact of that risk is. How do we go about assessing that? Thank you.
So this is because data protection probably not only the question to Henry, or not at all to Henry. Okay. You can grab the micro.
Yeah, thank you. So actually, I'm not sure whether I will answer your question directly, but there's just a broader point that I would like to make, and I think it touches upon what your question. And basically, this is sort of the paradox of risk, because on the one hand, risk holds the promises of making everything, sort of simple, and provide an easy tool for decision. So as we saw, we do the risk assessment, we do the risk management, and we implement the controls, and it's pretty straightforward, it's easy to use. So I think this is part of the attractivity of the risk, is that it's so appealing for this reason. But the paradox is that a risk is a sort of artificial construct, and this means that when you look deeper under the surface, this is the point where you find, all these intricate questions of methodology, of, how do you define the harms, how do you calculate the probability, how do you combine the magnitude of the harm and the assessment, who should be part, of the discussion around the table. And so I think this is also an important point, to say that there's this somehow paradoxical nature in risk, insofar in as much as it promises, simplification, but when you try to put it in practice, it's a sort of black box that can become very difficult to manage. And I think, this is part of this discussion that is ongoing about how to define the privacy harms and so on. So I think that's, sort of an important overall point.
So we promised to overrun the session only by 10 minutes, so 10 to 10 after 10. And you're very polite, thank you very much. So we have something more to say. Henry, I think.
All I wanted to say was that was the reason I used a healthcare quality example. In something as seemingly tractable as healthcare quality, they can't work out what the risk is that they are really regulating here. So I'm genuinely intrigued to know how you do it in data privacy. I'm just genuinely intrigued.
Okay. We have to get Henry to actually do one of these risk matrices for us based on privacy things. I think just because, Raphael, because this is difficult, because we're going to have to do things differently, doesn't mean we should not do it. We have to do it because we need to make sure that this privacy regulation and privacy compliance is effective on the ground. Number one, and second reason, and this is something that Claude has said, we are in the world where data is air. And so if we need some other metrics to enable us to use data-driven innovation, big data. And so we have to think about the benefits as well as risks. We can't stop things just because somebody there may feel that they're harmed by something when there are millions of people who can benefit. So that's why it's so pressing that we think about risk.
Oh, it depends whether this person will die or so. But we have two more questions, very good. So I think we collect those and then everybody gives the last statement. I do the summary and then there will be final words. So first you, I think, sorry.
Thanks. I have a question about your comment about the fact that the third-party assessment is time-consuming. In a context like big data, in which we have a high level of complexity, we cannot continue to imagine that self-determination, transparency, and so on are able to protect users and data subject. I think that the idea to having a third-party assessment, a multiple assessment, not only based on security, but also on social and ethical impact, could be important. And I ask you to clarify, why do you think that it is time-consuming? It's not possible due to the fact that we use the same approach in other fields. For instance, in product liability, when you buy a car, you need everything about the car, but someone certified the quality of the car, and so you don't take any risk, or you hope not to take any risk. Thank you.
Yeah. Okay, everybody got the question in the second one?
Hi, I'm Claudia Quella. I just started a PhD on the risk-based approach. And one of the things I'm really struggling with is how the risk relates to the legal requirements. Because even if you do say that compliance action and enforcement action is based on risk, but it doesn't touch upon the legal obligations, is that a distinction that holds? I mean, is that a meaningful distinction to make? And if there are similarities, is that enough to say, for example, that you don't have to do your information duties if the situation isn't probably very harmful at all? So at the end of the day, right, what does the risk assessment leave us with?
Okay, so Bojana goes first. Everybody else who wants to have the answers to the last statements or questions, please grab the micro afterwards.
And I'm happy to have further discussion with you, but I didn't say legal obligations are not important. They are important. It is how you apply the legal obligations where risk is going to play. So let me just say this. For example, if we are doing processing that we think is risky, more harmful, could have concerns, our transparency, our privacy notice, the requirement to inform individual should be much more robust, should be better layered, should be more information, because we are in the space of higher risk. Purpose limitation as well. If a risk is very high, maybe we are going to decide that the purpose, that next purpose is completely incompatible. Whereas if the risk is lower, maybe, and there is zero risk or no risk, maybe the purpose is going to be compatible. So that's all I meant. To the point of third-party assessment, I actually think this is a great idea, but look, I've been doing this job for 20 years, and every day privacy officers have to make these decisions, to apply the rules, to make decisions on how the law applies. They're doing these risk assessments every day, single day. So, and that's what our job is. That's why privacy officers exist. But, you know, maybe some oversight for some more complicated things. Claude?
I think with Claude, yes, it fits nicely because you wanted the risk assessment to be done by a third party, independent party. And this, I think, has to be characteristic for certification. Otherwise, the certification is crap.
That's right.
Yeah, I mean, I agree. I think there is a conflict of interest, right? That's why it has to be done by a third party. And I usually compare it to security analysis, where in security, the company has a benefit to make sure that this product or this company is secure. For privacy analysis, we're talking about humans, right? And some company, they might have more interest not to comply to privacy. That's why I think it's important to have like some kind of independent view. It's true that it's time consuming, especially for small companies, like so you were talking about cars and liability. In the case of car, we're talking about huge companies that have a lot of resources. For small companies, like handling data, it might be more time consuming, but that's why actually we're working on tools to try to automate this process.
Thank you very much. Thank you to the panel. Now I'm doing the summary. Nobody here on the panel proposed to employ the risk-based approach without regulation, without some legal basics. We probably had some differences in the definitions. Nobody challenged fundamental rights, although nobody knew how to calculate that. All saw practical problems in working with the risk-based approach, different problems and different ways or approaches to the answers, or the beginning of the answer, I like that one. And also working with risk has always played a role also in regulation, in legislation, with data protection outside the data protection field, and will probably play a bigger role in the future. So I think although we had probably different approaches, we have some feeling that there is the need to go on this road, although now there will be crossroads. We have to decide where to go, and I like also the very last question, what is now really the relation, how to solve that? And sorry, this time no answer, some approaches, but perhaps in 2 years' time after the regulation can be lived with, then we know a little bit more and we have to prepare much on this road. But your work will be appreciated on that. So, thank you very much to the panel, and then Daniel will say a few more last words.
Yes, before we close this session, I would like to make a quick announcement. I would like to announce a new privacy award, a new prize that will be awarded by the CNIL, so the French Data Protection Authority, and INRIA together. It will be a privacy award for a scientific paper with a major contribution on privacy protection. So it will be a published paper published during the last 2 years, so for the first edition, 2014, 2015. You will see more details on the website of the CNIL and of INRIA from tomorrow, because it will be announced officially tomorrow. The deadline for application will be early July, and the prize will be awarded at CPDP here in Brussels next year. So thanks for your attention, for your patience, and for your questions, and now it's time for the break.